present. A special thank you to Professor Krishna, who I've had the fond pleasure of interacting with on my visits to the Political Science Department. I'm particularly privileged to share this space with my guide and I believe my friend and mentor, Dr. Asadi ji, who has helped me think like a scholar. As lawyers, we stop in some senses being scholars, but thanks to his influence, I was able to go back to some amount of scholarship. And thank you, sir, for organizing this event. Professor Umapati, Mr. Kulkarni, other distinguished members of these two associations, Mysoreans, ladies and gentlemen. I think we've chosen a topic that is current and relevant and will get more relevant and controversial over the next few days. I'm quite sure that many of you have your own comments and questions on this topic, so I will be very happy at the end of my presentation to take any questions or comments that you may have. Before I go into the nitty-gritty of whether political parties should be part of the RTI and whether the proposed bill that Parliament has in mind is valid or not, let us first be clear on a theoretical framework. And that theoretical framework arises out of a very simple question, which is, can Parliament override judgments of the judiciary and of tribunals? Once we are clear on that question, I think we will be clear, at least as far as the legality of the proposed bill is concerned. I may say that the bill does not have just legal implications to it. It has some very serious political and, in a sense, ethical implications to it as well. And we will try and discuss those. But to simply address the question of the legality of this proposed bill, let me tell you, friends, that the doctrine of separation of powers that we enjoy under the Indian Constitution is not a very absolute or pure doctrine. This doctrine in theory simply says that it is the legislature that shall legislate, it is the executive that shall execute, and it is the judiciary that shall judge. And none of these bodies, in principle, should trample upon the space or the jurisdiction of the other. But this is, in a sense, a very ideal doctrine. In practice, we find that there is often a tug of war that goes on among each of these institutions. Of course, the judiciary must not legislate. It cannot legislate. It cannot even direct Parliament to legislate, because that is a pure sovereign function of Parliament. But having said that, many judgments that the courts pass, especially the Indian Supreme Court, are such that they have the impact of legislation. They operate like legislation. If you look at orders passed by the Supreme Court dealing with, for instance, prohibition of tobacco, this was an order that came to be passed even before the Tobacco Prohibition Act was in place. If you look at police reform, Prakash Singh's case, the Supreme Court has issued directions to revamp the entire police establishment in India, which has virtually the effect of a law. You look at the judgment in Vishaka's case, where the Supreme Court has directed that there shall be a regulation in respect of sexual harassment at the workplace, and that is applicable across the country. So all of these directions, in many ways, I would not say amount to legislation, but they have the effect and the force of law. And this has not always gone down well with the other limbs. Parliament has often grumbled that the judiciary is usurping its function. But the judiciary, on the other hand, has a good explanation, which is that if legislature has failed to legislate on matters of public importance for 60 years, the executive has also failed to issue appropriate executive orders, and the fundamental rights of the citizens are being prejudiced because of this vacuum in the law, then there is a need for the courts to step in and issue appropriate directions. But this overlap is difficult to justify at all times. There are many times when one finds the judiciary stepping into the legislative domain, and on the other hand, the legislature, which is supposed to implicitly obey all judgments of the court, we often find that the legislature tries to override judgments by way of fresh ordinances and fresh laws. And that is the key question we have to understand before we address this question as to the validity of this proposed RTI bill. So is it that Parliament in no circumstances can pass a law to override a judgment? Well, the answer is no. It can. I'll give you an instance. Supposing the Indian Institute of Engineers letting out this auditorium to the IIPA and the University Association was charged with service tax on the ground that it is providing a service. One of the questions that may arise if the matter went to court is this provision of an auditorium for a lecture a service that is recognized under the service tax law? And let us assume, I'm giving you a theoretical and a simplistic example, let us assume that the law does not provide for the letting out of auditoriums as a service. And on that ground, let us therefore assume that a court of law holds that the union government cannot levy a service tax on such a service. That judgment may be final, but it does not preclude the government from bringing in a law, amending the Service Tax Act and saying we now introduce the letting of an auditorium as a service that is taxable under the service tax law. And this it can do retrospectively, and it can validate it. And if it does so, it is very much within its power to bring in a new legislation. And the reason for that is, it is not overriding the judgment. The legislation is not saying that the judgment of the Supreme Court is wrong. What it is saying is, the very basis for the judgment has now been taken away by way of an amendment. To that extent, Parliament has every power to do this. And the Supreme Court itself has said it. Let me tell you, friends, that many of these legislation come, as you may have seen in the Vodafone case. The Income Tax Department lost before the Supreme Court. It then sought to amend the Income Tax Act, the Finance Act, retrospectively to bring into force new amendments which have the effect, in a sense, of nullifying the judgment. But in all these cases, when the amendment is challenged once again in court, the Supreme Court itself has graciously said, look, this is not overriding our power. We gave a judgment on the basis of a law that existed on that day. Now the Parliament in its wisdom has chosen to change the position in law. Once the change has come about, that by itself is not a ground to fault Parliament. But the problem arises when Parliament chooses to legislate simply to override the judgment. There is a distinction. This distinction I can point out to you by a very real and recent example. The Supreme Court recently, as you're aware, passed a judgment that any member of Parliament who has been convicted within the meaning of the Representation of People's Act would stand automatically disqualified. As a result, as you know, two people, including Mr. Lalu Yadav, have already been disqualified as of last week. Now, the provision under the Representation of People's Act, as it stood earlier, had a provision under Section 8, subsection 4, which said that this disqualification shall not take effect for a period of 3 months, or if an appeal has been filed by the concerned convict, and so long as that appeal is pending. Now, this was struck down by the Supreme Court. Supreme Court said, under the Indian Constitution, the disqualification must take effect forthwith. If that is the case, by way of a subordinate law, that is the Representation of People's Act, you cannot override the Constitution and defer it. And therefore, that provision of law is unconstitutional, it is ultra vires. Now, that took effect immediately. Parliament was obviously rattled by it for the same reasons that the political parties are rattled by the RTI judgment, which is it affects their tribe. You don't see this this urgency on the part of Parliament to legislate when it comes to other matters. The Lokpal bill has been languishing, the whistleblowers bill has been languishing. There are a number of other beneficial legislations that are just pending in Parliament for years. But when it comes to matters that affect our friends in Parliament, they act rather quickly. Be that as it may, in view of this judgment in Lily Thomas's case, Parliament proposed a bill to simply undo the judgment, to simply say that notwithstanding anything contained in any judgment of any court, the disqualification shall not take effect immediately, but shall take effect only after 3 months. Now this, of course, when Mr. Rahul Gandhi made a comment that the bill is nonsense and it should be torn up, it was promptly dropped. But had this bill seen the light of day and become a law, I have no doubt that this law would have been struck down, because it does not remove the basis of the judgment of the Supreme Court. It simply overrides it. Supreme Court said you cannot defer disqualification. So what do we do as Parliament? We come up with a law and say, no, notwithstanding a judgment, we can defer. So what you're doing in effect is, you're annulling a judgment. You're not removing the basis for the interpretation. You're annulling it, you're overreaching it, and you're saying that it is void. And that can never be countenanced. One of the basic principles of separation of powers is that we have an independent judiciary. It is only a court that can say that a judgment of another court is void. It is not Parliament who can say that a judgment is void. So I have no doubt that in such cases, such a proposed amendment would have been struck down. Of course, better sense prevailed, or Mr. Gandhi's sense prevailed, I don't know, but the bill was dropped. Now this was done even once before, friends. The Supreme Court in a particular judgment had said that in addition to all the disclosures that a candidate for an election has to make, there are 2 additional disclosures that have to be made. One is your assets and the other is your educational background. Now the law nowhere required it. This was, one may say, judge-made law, as I was alluding to earlier. Legislation by the court virtually. Supreme Court said you must make these 2 disclosures in public interest because a voter has the right to know. He has a fundamental right to know the financial and educational background of the candidates that are standing before him. What did Parliament do? Since it affected them, very promptly they amended the Representation of People's Act and said the same thing, that notwithstanding anything contained in any judgment, only the following disclosures shall be made and no others. And naturally, these 2, that is the assets and education, were excluded. That was challenged in the Supreme Court. Supreme Court struck it down, saying it is unconstitutional. You have no power to make a law simply to annul a judgment. So that settles the proposition as far as I am concerned, that Parliament may have the power in certain circumstances to remove the basis for a judgment by amending the law, by doing away with the provisions that were interpreted by the court. If it is a bona fide exercise, the courts will uphold it. Courts have upheld it. But if Parliament simply tries to overreach a judgment, simply undoes a judgment, then it would be frowned upon, it would be struck down by the courts. So it is in this background that we need to examine this cause of action that has now arisen. It's very important, friends, to bear in mind 2 aspects which are fact specific. One is that there is no reference to political parties in the Indian Constitution, except for Schedule 10, which deals with disqualification in a situation of defection from one party to the other. There is no other provision in the Constitution which expressly deals with political parties. Either the constitution of a party, the establishment of a party, the powers and role to be played by a political party, or any other aspect. This strikes me as a little surprising, because we are a democracy and democracy is meant to be part of our basic structure, and there is no gainsaying that a political party system is integral to Indian democracy. We are not a 2-man race. We are not a presidential form of government like the US, where you have 2 individuals facing off over a debate and taking a stand. No, we even today, I believe, more or less vote for a party, vote for an ideology, and not always vote for an individual. But funnily enough, even though political parties are so integral to our democracy, they find no substantive mention in the Constitution. They are in that sense extra-constitutional. They are no doubt recognized under the Representation of People's Act. There is a procedure for registering a political party, getting a symbol, etc., etc. I am not on that. My point is that when something like a political party is so closely interlinked with politics, with democracy, it is a bit curious that there is no whisper about it in the Indian Constitution. If you gave the Indian Constitution to somebody who doesn't know anything about India and ask him to read the Constitution, he will never mention a political party as an integral part of Indian polity and Indian democracy. But please remember, friends, that this is the situation that has been exploited by political parties. I was speaking, sir, some time ago at the Professor B.T. Patsarthi Memorial Seminar. He was the former Advocate General of Karnataka and a very fine man. And the topic there was with respect to political parties in the Indian political paradigm. And one of the points that I made was that Indian democracy is suffering because of post-poll alliances. You vote for a particular party or a pre-poll alliance. You know what the UPA or the NDA is and you vote for them. But the combination that comes to power is not who you voted for. It comes with an addition. Sometimes the left is added or sometimes the right is added. Sometimes a few new parties are added who have no ideological synergy. And as a result, you have a hotspot that we are seeing today. Our Prime Minister has openly said, coalition politics. Whenever he is in a tight spot, which seems to be quite often, he always says these are the fatalities or the casualties of coalition politics in India. And I believe that post-poll alliances are unconstitutional. But the problem is, and I put this question even to former chief election commissioners, not one but two of them, sir. And both of them have deflected this question. Because nobody wants to change the status quo. The status quo works very well, and if you do away with this, the entire house will come crumbling down. The point for me that is significant is that it is this vague setup that we have, where you have a prime minister, you have a president, you have other constitutional bodies, but who really works Indian democracy is the parties. Let's be frank about it. At least in the kind of leadership we've had over the last few years, I don't think even the cabinet overrides the party. There are power centers within the party, not within the cabinet, not the prime minister, unfortunately, who pull their weight. And this is an important factor. Why this factor becomes important is in the context of the RTI dispute. You see, some folks filed an application to all these political parties, Congress, BJP, BSP, CPIM, so the main 6 or 7 parties, asking for information. All of them said, with one exception, I think the CPIM, where one of their officers rather fairly said, yes, we are covered. All of them said, we are not a public authority. We are not required to furnish any information to you under the Act. And these RTI activists then approached the CIC, the Central Information Commission, filing an appeal saying that, look, these parties are nothing but public authorities. And this point that I'm making about them being constitutional or public bodies becomes relevant in that background. The reason for that is the only way you can determine whether an authority is a public authority under the RTI Act is if it is substantially funded by the government. Of course, you can, if you're a constitutional body or a statutory body or you're specially notified by the government, there is no dispute. You're covered by the RTI Act. Obviously, Mysore University being a statutory body, ipso facto is covered by the RTI Act. There's no dispute about it. I am talking about bodies like the political parties who have no constitutional or statutory basis. The Congress party is not constituted under a special statute. You don't have a Congress Party of India Act. If you did, automatically it is a public authority. Therefore, the key question before the Information Commission was, are political parties public authorities? To answer that, according to me, the only question that should have and could have been gone into by the tribunal was, is it substantially funded by the government? It answered that. I'll be coming to that in a little while. What it also did, to my discomfort, is that it went on to expand on how important political parties are in the Indian political space. According to me, that discussion is completely irrelevant. It's a very relevant conversation in a political background. It's an irrelevant discussion when it comes to the law. The RTI Act does not deal anywhere with the definition of a public authority other than it being substantially funded. So the Information Commission has actually gotten quite carried away. It has said political parties by default make policy, by default they make the law. I don't think so. That may be what is happening on the ground, but a political party is not synonymous with parliament. You are elected to parliament. Political parties don't have an election, certainly not a general election. They may have their own internal election. That's a different matter. But the right to make law for a citizen of India is vested only in parliament. And I think the CIC in its exuberance has gone a step ahead and equated political parties with parliament and said law-making power, policy-making power, implementation of policy, all of this is vested with political parties. They've even said it has a constitutional color. All of these points, according to me, with great respect to the CIC, are incorrect. They may be well-meaning, but that is not the jurisdiction of the CIC. Now, why this aspect becomes relevant to me is, none of the parties who were parties before the CIC, these 6 main political parties, have chosen to challenge the judgment of the CIC. It's a very important aspect. It was open to them to file a writ petition in the Delhi High Court, question the correctness of the judgment of the CIC. They may even have succeeded, we don't know. And they could have gone all the way to the Supreme Court. But for whatever reasons, and I am not able to see those reasons, to me it's inexplicable that you will get so desperate that you will not even file a writ petition challenging an order of the CIC, but straight away get into lawmaking mode. It's quite unprecedented to me, sir. I have seen many instances where Supreme Court judgments have been sought to be undone because Supreme Court is final. Hardly ever have I come across a case where a tribunal's judgment, which has not been challenged further, has been sought to be undone by law. So it's a bit of a desperate measure, I see it. It's in a sense an abuse of constitutional power. It's premature. Even today, it is open to these parties to file writ petitions. What the parties have done in the process of coming up with a bill to undo the judgment is, they have proved the point that political parties and parliament are synonymous. The government of India was not a party to the CIC. It was only Congress, BJP, BSP. But, well, birds of a feather flock together. And they've pulled their weight, they've come up with a draft bill, which is now up for public scrutiny by you and me. Now, this bill is something I want to talk about. Before I do that, let me tell you what the strong point of the CIC judgment is. Where the CIC judgment has correctly held that political parties are indeed public authorities is on the basis of the government funding that these parties receive. You will be surprised to know, friends, and this was news to me when I read the judgment, as to the extent of public money, directly or indirectly, that is going into the corpus of the various political parties. The judgment has a tabular statement of immovable properties, tax exemptions, other bonuses, financial grants, airtime on Doordarshan and national newspapers that has been given either free of cost or at a highly subsidized cost to these parties. I mean, I was reading the office of the Congress party in Delhi, somewhere in central Delhi, based on market value today, is worth more than 1,700 crores. It was shocking. I had no idea. And it may not be so high when it comes to the BJP or the others, but take it from me, they are all enjoying a bounty. Added to that is tax exemption running into crores of rupees, free time on Doordarshan, etc., as I said. And looking at all of that, there is no doubt that the quantum, the mammoth quantum of funding that is going into political parties is such that it's clear that they are substantially funded. What is substantially funded? That becomes a point for lawyers. Is it simply 1,000 crores that makes it substantial, or is it the ratio of that 1,000 crores to the corpus? Now, the Supreme Court, in a judgment that came after the CIC, in Talapalam Cooperative Society's case, the Supreme Court said that substantial is a subjective concept. And how substantial the government funding to a particular body is very fact specific. The question is whether that funding is such that the body cannot otherwise survive without it. So let us say the Indian Institute of Public Administration. Its corpus theoretically, let's say maybe 1 crore. It may be receiving 25 lakhs from the government. On face value, 25 lakhs may not seem substantial considering its corpus is 1 crore. But if one looks at the balance sheet of the IPA and finds that for the last 10 years, the only reason it has been able to carry out its activities is because of the presence of this 25 lakhs. And but for this support from the government, it would have been a negative balance sheet and it would have had to close down. Then the court may say, well, 25 lakhs is also substantial. In a company, if one controls more than 26% of its equity, that's a substantial share. So if the government, by way of its funding or control, has more than 26% in a company, that company could be a public authority. So on all these fronts, I find actually that the CIC has correctly decided that because of the kind of funding that all these political parties are receiving, they are nothing but public authorities and therefore amenable to the RTI Act. Political parties, however, as I said, chose not to challenge this judgment. They quickly went into legislative mode and came up with the bill. Now, if we look at this bill, I can tell you friends, on the face of it, it is illegal. Let us keep aside the morality of it. We'll talk about that. Simply, legally speaking, the bill will not stand. In fact, it has already run into hot water. The Attorney General, credit to him, has given his opinion to the government that it is better you don't promulgate this. It is better that you challenge the judgment of the CIC if you want to. And the reason for that is, the bill says exactly what some of my earlier illustrations said. That notwithstanding anything contained in section 2H of the RTI Act, by way of explanation, a political party shall not be deemed to be a public authority. Arey, what is so special about you? You are a public authority by interpretation, just like thousands of other public authorities. Why should you be specially excluded? Is it not discriminatory? What is so special about a political party that it must be excluded from the RTI Act when hundreds of other institutions are brought into it by way of interpretation? Is it rational? Is it not arbitrary and abuse of power? That is one aspect. On that ground itself, it will go. The other aspect is, the most interesting thing I thought, is the statement of objects and reasons for this proposed bill. It has some incredible statements. I think obviously in their anxiety to undo this law, there's not a lot of grey matter that has gone into it. What do they say? They say that political parties are already amenable to a lot of disclosure under the Representation of People's Act and under the Income Tax Act. Political parties are required to make a disclosure as to what their revenue sources are. It's true, under both those acts, every donor in excess of 20,000 must be recorded, and that entire record must be placed before the Income Tax Authority as well as before the Election Commission. But if that is so, in any case, your information is in the public domain. So are you worried that you will become too transparent? Is there such a thing as too transparent? Is not transparency the reason the RTI Act was brought into force? And on the other hand, it is not as if all information can be sucked out of the RTI. One of the concerns in the bill is that political rivals will misuse the RTI Act to get information out of me. Well, right now it seems like there are no political rivals, they are all friends. All of them want the law to be changed. But even if that is the case, is that not a risk every organization faces? That somebody will misuse the law, somebody will abuse the law. We have seen it. Asadi Saab is an administrator of a Waqf body, which is not a public authority. Some gentleman filed an application saying, give me RTI information. Correctly, he said, we are not covered by the RTI. However, the State Commission said, you are covered by a non-speaking order. We filed a writ petition, got the order stayed. It's not that the RTI Act can be used to my office or your office unless we satisfy the definition of public authority. That's one aspect. Second thing, very importantly, friends, is that there are exceptions carved out in the RTI Act itself. Section 8 has as many as 8 or 9 exceptions as to in what circumstances information can be refused. They include everything from sovereignty, security, privacy matters, etc., etc. So all those exceptions in any case are available. So if somebody makes an application to a political party to disclose, let us say, the roster of candidates that were considered before the election list was finalized, the short question for me would be, is that information in any way exempted under Section 8? If it is exempted, don't share it. But if it is not exempted, please share it. Don't say I am a special creature, I am a political party, I am not required to disclose this information because of XYZ reasons. Well, what is sauce for the goose is sauce for the gander. If you have secret information, you have information that is sensitive, and you want to cover yourself from the RTI, well, so does everybody else then. Why didn't you think of this before you brought the Act in? It is the UPA government that has gone to town saying that one of the greatest pieces of legislation we have introduced is the RTI Act. Is this not hypocrisy? I have introduced RTI, please use it freely against everyone, but don't use it against me. That is not, I'm afraid, an argument that will stand in law, and it's not an argument that will stand morally. It's not right. It will not even, I feel, take them anywhere politically. It looks bad. It looks bad when the people see that politicians want to cover their backs. And that is the impression we are all getting. As it is, the level of faith and trust in the political establishment is reducing every day. People have started to lose interest in elections. As much as the next general election is around the corner, there is also a general sense of disquiet that they're all one and the same. What difference does it make? That is the kind of despair that is setting in. And that's a very serious matter. This whole Naxal movement that we're seeing, I don't want to digress, but a good part of it is born out of a general sense of frustration against the Indian state, and we can't ignore it. And if this is the kind of political threat that our establishment is facing, this is not the time to be playing these games. Playing a game to try and cover yourself, to cover your turf and save yourself. It doesn't look good legally, it does not look good politically, and it certainly does not look good morally, is my respectful submission. Over to you.